Hello, everybody. It's Walter, your favorite historian, educator, professor, and social studies extraordinaire, here today to give you some constitutional analysis with respect to the U.S. Senate's refusal to hold an impeachment trial for President Biden's Homeland Security Secretary, Alejandro Mayorkas. Now, you may have seen it in the news, I don't see how you couldn't have by now, that on yesterday, April 17, 2024, the United States Senate, led by the Democratic Party, summarily dismissed the articles of impeachment that had been filed by the Republican-led House of Representatives against President Joe Biden's Homeland Security Secretary, Alejandro Mayorkas. Now, this was an unprecedented event, folks, that indeed the Senate has never before dismissed articles of impeachment against any federal official that had been impeached by the House of Representatives in all 240 years that this has been happening. Okay, the Senate has always conducted a trial, or if not, the person has resigned before a trial could begin or before a vote on the impeached individual could be taken. But in any case, a trial has always occurred, and the charges have never been dismissed against anyone who was impeached. That's the bottom line with this point that I'm trying to make. However, with that in mind, you have seen also that Republicans in the Senate and the House have absolutely lost their shit about this. That the Democratic-led Senate has absolutely, in their mind, abrogated and thrown its constitutional duty in the trash by dismissing the justly drafted articles of impeachment against Secretary Mayorkas. You've seen prominent Republicans, Senators Ted Cruz and the senator from Utah, who are trained lawyers, make incorrect constitutional arguments here that the Senate had an obligation, a duty, a requirement to hold a trial for Mayorkas. Interesting that these two are lawyers and don't know the basic language of the Constitution. Now, the Constitution of the United States, of course, vests the U.S. Senate with the power to try an impeached individual by the House of Representatives, as well as confirm individuals named to federal offices by the President of the United States. In both circumstances, this power is exclusively discretionary, folks. There is no mandate, no force, no requirement that the Senate do either. They have the choice, under the language of the Constitution, to do either one at their discretion. Just like the Senate exercised the choice to not hold any hearings or a vote on President Obama's final appointment to the Supreme Court in 2016, D.C. Court of Appeals Judge Merrick Garland. Yeah, remember that, Republicans? You all never acted on the nomination at all. You even refused to give Merrick Garland the courtesy of a hearing and up and down vote. So, you're mad because Democrats gave you a taste of your own medicine here? You don't like it when the Democrats play hardball. But I must say, I'm very proud of them for finally showing some guts and sticking it to you all, showing you how it feels for once. Just as you unjustly didn't even give Merrick Garland the courtesy of an up and down vote in 2016 when President Obama nominated him to the court almost a year before he left office. Guess what? Your pathetic, useless, bullshit articles of impeachment against Secretary Mayorkas, also were thrown in the sewer. So, I don't just throw shit out there. I back it up with facts. Let's read the language of the Constitution to prove to you that this power that the Senate has with respect to impeachments is absolutely discretionary. In the same way, it is discretionary with respect to confirming officials nominated by the president. Okay? So we begin with impeachment. All right? So, Article 1, Section 3, Clause 6 reads as follows. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Nowhere in that language does it say the Senate must hold an impeachment trial. Nowhere does it say the Senate must vote to convict or acquit an impeached individual. The Senate is given implied discretion here, ladies and gentlemen, to decide whether or not they will act on an impeachment. They have that power to decide whether or not they will consider any impeachment articles given to them by the House. In no way is it mandated. Only thing it mandates is that when an impeachment trial occurs, the Senate has to be the body to do it. End of story, bottom line. Let's move on to the president's appointment power, all right, with respect to the Senate confirming his appointees. Article 2, Section 2 of the Constitution, ladies and gentlemen. Article 2, Section 2, Clause 2. Speaking about the president, he shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may, by law, vest the appointment of such inferior officers as they think proper in the hands of the President alone, in the courts of law, or in the heads of departments. So you see in both of these sections, folks, the Senate's power is absolutely discretionary. They don't have to act on impeachment articles brought to them by the House, and they don't have to act on a president's nominee to any federal office, including the judiciary, and even more narrowly, the Supreme Court. So you see the Republicans throwing a bitch fit about this, that the Democratic-led Senate dismissed the articles of impeachment against Secretary Mayorkas. They weren't throwing that fit in 2016 when their then Majority Leader Mitch McConnell absolutely positively refused to even hold hearings on Merrick Garland, let alone give him the decency of an up and down vote. Republicans, you can't have it both ways. The language of the Constitution is very, very crystal clear here. The Senate has the absolute discretionary power to act on appointments and impeachments. No language in the Constitution compels them to do so. So if you're gonna whine like little babies because the Democrat-led Senate dismissed the articles of impeachment against Mayorkas, just remember, you guys set the precedent in 2016 with Merrick Garland to not act on your quote-unquote constitutional duties. No person can be confirmed to a federal court or any other federal office as mandated by the Constitution without the Senate's consent. Similarly, no impeachment trial resulting in a conviction or acquittal can happen without the Senate. But in both circumstances, ladies and gentlemen, the Senate's power here is absolutely discretionary. Okay? They did not have a duty to act on Mayorkas' impeachment articles given to them by the House. Just like they didn't have a duty to act on President Obama's last nominee to the Supreme Court, Merrick Garland. So if we're going to make that argument that the Senate doesn't have that, is not mandated to do it, we're going to be fair. They're not required to do either one. But the Republicans like to have a double standard, that they are the ones that get to run roughshod over the Constitution. But the moment the Democrats do the same thing and give them a taste of their own medicine, they want to be up in arms and whine like little babies. Well, I'll conclude by saying you can't have it both ways. Don't dish what you can't take. So that concludes my video and my constitutional analysis of the Senate's dismissal of the articles of impeachment against Secretary of Homeland Security, Alejandro Mayorkas. Any questions or controversies, leave them down below. I'll be happy to answer them. Until the next video, take care of yourself, stay safe out there, and have an awesome day. Professor Shelton.